Hello and welcome to Awareness Self-Directed Training. We're going to be reviewing the Nova Scotia Occupational Health and Safety Act, and we are doing mini module 11, which covers sections 73 to 81 of the Act, and this is the 11th mini module of a 12-module series. So the power to arrest is what we're going to cover in this particular slide, and a police officer who was responsible and has probable grounds to believe that a person is failing to comply with an order may arrest a person without a warrant and shall take the person before a judge as soon as practical. A person taken before a judge in such a situation as described above is entitled to an immediate hearing. If this is not possible, the person shall be released from custody and understand that they must appear to answer to the charge at a time and place arranged by the judge. A police officer who arrests a person in this type of scenario shall promptly inform the person of the reason for the arrest and the right to retain and instruct counsel without delay. Offenses and penalties. A person who violates the act or regulation, fails to comply with an order or a direction or adopt a code of practice, is guilty of the offense and liable for summary conviction to a fine and to terms of imprisonment not exceeding 10 years, or both a fine and imprisonment. The fine will not be more than $250,000. And for a second and subsequent offense within 5 years from the date of the conviction of the previous offense, the fine of not more than $500,000. Regarding the fine for the first offense, if the offense results in a fatality, the person is liable to a fine not more than $500,000. In addition to the fine imposed, the court may impose a fine not exceeding $25,000 for each additional day during which the offense continues. So that there is a conviction that's under the legislation. It can be, 2 years in prison, or $250,000 or $500,000 for a second offense or fatality. And if you're violating an order of the court or of an order of the law, the act and regulations, you can be fined up to $25,000 a day. And that's for each order. When a person is convicted of an offense as it relates to the act and it is determined that the offense gained monetary benefit while committing the offense, the court may order the offender to pay a fine in the amount equal to the estimated amount of monetary benefit in addition to the original fine. Powers of the court on conviction. When a person is convicted of an offense related to the act in addition to a fine imposed and any other punishment imposed by the act, the court may make an additional order based on the nature of the offense and the circumstances surrounding the commission. An order might be direct the offender to publish the facts related to the offense, direct the offender to pay the minister an amount of the purpose of OHS incentives, including but not limited to public education, direct the offender to perform community services, direct the offender to submit information detailing the activity he or she has been involved in which the court considers appropriate and just in the circumstances, requiring the offender to comply with other reasonable conditions as the court considers appropriate, which will ensure that the offender's good conduct and prevent them from repeating the same offense or committing other offenses. So this all outlines the ability, what some would call creative sentencing, where they might make them take an ad in the paper, speak at safety conferences or such. As well, Where the offender fails to comply with the orders directed, the publication and the facts related to the offense, the director may publish the facts in compliance with the order or recover the cost of the publication from the offender. Where the court makes an order directly the offender to pay an amount for the purpose of OHS safety incentives of the director incurred publication cost as above, the cost contributed as debt due to Her Majesty in the right of the province may be recovered in a court. When an order is made in regards to any of the previous mentioned scenarios, it goes into effect on the day in which it is made, and on another day as the court may order, and will not continue for more than 3 years after that day. Deemed act or omission of employer. In a proceeding or prosecution against an employer related to the act or regulations, the act or omissions of the manager, superintendent, or other persons who exercise management function for the employer is deemed to be an act or omission of the employer. However, there is a provision that the employer took every precaution reasonable in the circumstance to ensure the act or the omission would not occur, and the employer did not have actual knowledge of or could not reasonably have known the act or omission and did not express or imply consent to the act or omission, then the employer is not deemed to have committed an act or omission. So there's sort of some other related topics. Participating in an officer, director, manager, or agent of a corporation who directs, authorizes, or participates in the commission of an offense related to the act is guilty of that offense. Immunity from civil action, an officer, committee, member of a committee, representative, the director, the board, member of the board, the director of labor standards, where the person or the body is acting in accordance to authority of the act and regulation, shall be immune to the actions instituted against them and any losses, damages, suffering by a person because of the act or omissions done in good faith by the person or the body. And there's more detail in Section 78 on this. Elimination period for prosecution. A prosecution of an offense related to the act shall not be commenced more than 2 years after the later of the date in which the offense was committed or the date in which the evidence of the offense first came to the attention of the officer. So we look at the analysis. The minister may appoint as an analyst any person in the opinion of the minister has the qualification and experience to be appointed and shall perform such duties and carry out such duties may be determined by the regulation. No documents of an analysis may be received in evidence unless the parties intend to produce it and give it to the parties against whom which is intended to be used. Reasonable notice of intentions together with a copy of the document. The parties whom a document of analysis is produced may, with leave of the court, require the attendance of the analyst for the purpose of cross-examination. So this is any testing, any data that comes in that, you know, it follows normal court proceedings. Proof of order and other documents. In any proceeding or prosecution related to the Act or the regulations, any of the following listed items shall be admitted as evidence, as proof of the order, decision, notice, report, certification, or document and their contents without proof of signature or original character of the person appealing. It may be signed and may sign the order, the decision, the notice, the report, certificate, document in any case may be. A copy of the order, decision, notice, report, or certificate claiming to have been made or issued because of the Act or regulations. The claims to have them signed by a person authorized to make or issue the order, decision, notice, report, or certificate. A document claiming a copy of the notice, drawing, report, or other documents given or made based on Act or regulations and claims to be certified by the officer or analyst. The document claiming to certify the results of a test or an analysis of the sample of air is set forth the concentration and the amount of biological, chemical, and physical agents in the workplace as part of the workplace and claim to be certified by an officer or an analyst. So this really, it's a lot of, it sounds like it's saying all the same thing, but the short version of this is just making sure that all the I's are dotted and the T's are crossed, that everybody, that the right people have all the right documents, they've all been certified, and so forth. A document claiming to certify the results or the tests of an analyst of any equipment, machinery, evidence, article, thing, substance, and claims to be certified by an officer or an analyst. The document claiming to be signed by an officer stating that the report requested, noticed, and order was and is not given or received. A document claiming to be signed by a person authorized under the Act or the regulation to issue a certificate of examination or authorizing a deviation, states that on a special day or giving a specific period, a person named in the document was or was not the holder of the certification of examination or authorization of the related to the Act. The document outlining the conviction and the sentence of a person for an offense committed under the Act or regulation, claiming to be signed by the person who made the conviction or the clerk of the court and where the conviction was made. So that is the end to what is probably the most sort of legally affected section in mini module 11. You now need to complete the post-assessment. If you get all of the answers correct, it'll send back a message saying thank you. If you get one or more answers incorrect, it'll say try again. Just go back and redo the test, and we'll move on to our final module.